We're very pleased to welcome you to this very special event. Before we begin, can I ask everyone to please switch off their mobile phones or put them on silent so as not to disturb the proceedings? My name is Shan Katari Libby, and I'm an advocate here in Chennai. It is my pleasure to invite to the stage at this point Justice Nariman, Justice Kureshi, Advocate General P.S. Raman, and Senior Advocate Sriram Panchu. If you could please take your seats on the dais. We will begin the proceedings with the Tamil anthem, Tamilthai Vartha. If everyone could please rise.
நீராறும் கடலுடுத்த நிலமடந்தை கெழிலொழுகும் சீராறும் மதனமென திகழ்வரத கண்டமிதில் எக்கணமும் அதில் சிறந்த திராவிடனல் திருநாடும் தக்க சிறு திரை நுதலும் தரித்தனரும் திலகமுமே அத்திலக வாசனை போல் அனைத்துலகும் இன்பமுற எத்திசையும் புகழ் மணக்க இருந்த பெரும் தமிழனங்கே தமிழனங்கே உன் சீரிழமை திறம் வியந்து செயல் மறந்து வாழ்த்துதுமே வாழ்த்துதுமே.
We would like to begin by inviting Senior Advocate Sriram Panchu, who was one of Mr. Govind Swaminathan's long-standing juniors, to please deliver the welcome address.
Justice Nariman, Justice Kureshi, Mr. Balatraman, distinguished invitees, students, ladies and gentlemen. For us in Mr. Swaminathan's chambers, it is an absolute honor and a privilege to hold this function to honor Justice Kureshi in the presence of Justice Nariman, to have Mr. Raman with us, and to have all of you with us. Thank you so very much. Recently, Justice Oka of the Supreme Court said something. He said at all functions which we observe in connection with the law, we should invoke the Constitution. And we have started to do that. All of you, I think, would have been given copies of the preamble. Please do repeat the preamble loudly after me. With your permission, sir, I will administer it. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you very much. It is my pleasant duty to do the welcome this morning. All I need is a friendly iPad. Yes. Let me speak a little bit about my senior, Mr. Govind Swaminathan. He was born in 1909. He schooled partly in India, partly in England. He went on to Oxford, was called to the bar of the Inner Temple. He came back to Madras to begin practice in 1935, firstly as a criminal law practitioner. He became Crown Prosecutor. Then he moved to civil and constitutional law. He was appointed Advocate General in 1969, which post he held till 1976, and he made it a point to appear himself in the significant cases for the state before the Supreme Court. Later on, he was Commissions Counsel after the emergency into the scandals dealing with the Nagarwala death and the purchase of VIP Boeing aircraft. That was the Jagan Mohan Reddy Commission. The International Bar Association conferred on him the Legend of the Law Award. He passed away in 2003, crossing this bar to the ultimate elevation. He was a consummate lawyer, but more, he was an even finer human being. Once you were within his circle, it was like a constant life protection plan. He was so many things. He was senior, he was part father, he was guide, he was friend. He was, to use a phrase from a book, he was the constant gardener in your patch of the field, as he was in so many fields, to so many others. He lived by example. When he was around, we had no need of a code of conduct. We just had to ask ourselves, what would he do? And principles meant all to him. He spoke his mind, he called a spade, and he did the right thing, not for any credit, but simply because it was the right thing to do. We have instituted this award in his memory. It is earlier, the honors have gone to Justice J.S. Verma and to Mr. Fali Nariman. Today, I think Mr. Swaminathan would surely approve of the recipient of the award in his name. Justice Akhil Kureshi has become the byword for judicial integrity and independence, for embodying the finest judicial values, for upholding the Constitution and the laws without fear or favor. It is sad to say that the Collegium failed us in not appointing him to the Supreme Court, despite Justice Nariman's best efforts. It is not just that the Supreme Court lost an asset. I think the Supreme Court became less of an asset when it didn't appoint Justice Kureshi. But surely it is no loss to Justice Kureshi. He will go down in history. When I told Justice Venkatachalaya that we're having a function to honor Justice Kureshi, he said, oh, the great martyr. Yes, you must honor him. So he will be like Justice Learned Hand of America, the one judge whom everybody said should go to the Supreme Court. It's a court of 9. Learned Hand didn't make it. But he's always called the 10th judge of the Supreme Court. The other 9 come and go, but learned hand is always the 10th judge. So similarly in India, I think Justice Kureshi will always be the one who should have been there. So no retirement at all for you, sir. There is a formal introduction to him, there is a citation to him, and all that will be read out. So I will not dilate on that, but let me share a couple of other aspects. Justice Kureshi's great-grandfather, Imam Sahib Bawazir Qadri, had settled down in South Africa. He was deeply influenced by Gandhiji's ideas and joined him to return to India, leaving behind his business there. In Gandhi Ashram at Ahmedabad, he built a small house called Imam Manzil, where he lived the rest of his life, and where his, Justice Kureshi's grandfather, his son-in-law, daughter lived, where his father was born. It was the property of the Ashram Trust and was returned to the trust once grandfather passed away. It still stands there. Justice Kureshi's father grew up in proximity to Gandhi in a family whose devotion to the nation and to Gandhi was absolute. This is the kind of man we honor today, not just because of his judicial accomplishments, but because he represents something so important to us, this idea of a composite India where we are all one. A brief word about Justice Rohinton. To those of us who revered Fali Nariman, and I count myself as one of them, he is a worthy son. In his own right, a brilliant lawyer, a brilliant judge who carved his own path and held firm at all times. After retirement, he has become the public educator of our times on law and society. He speaks about great judges, great cases, great causes, contemporary legal developments. If you want, an education in law and society, please, you must visit Justice Nariman on his YouTube. He's scholarly, he's depthful, he's interesting, because he's so engaged with his audience. And, I've seen him, I've heard of him, I've watched him, briefly interacted with him. But there is so much learning in this man, so much to learn from him about law, about the universality of religion, about music, about living life well. Indeed, it's just absolute. So I welcome both of them. This is a standout event. I must confess that I had some difficulty in the preparation of this event, because Justice Nariman said, the function belongs to Akhil Kureshi, I will not speak longer than him. And Justice Kureshi said, nothing doing, Justice Nariman is senior, I will not speak longer than him. So I was facing this grim prospect of, function where both my star speakers strove to take the minimum amount of time possible. But luckily we have arrived at a happy compromise, and both of them will speak for half an hour. But I want to tell you, sirs, that half an hour is your floor. For this audience, you have no ceiling. Thank you very much, all of you.
Thank you, Mr. Panchu. We would now like to invite Advocate General of Tamil Nadu, Mr. P.S. Raman, to deliver the presiding address.
Justice Nariman, Justice Kureshi, Mr. Panchu, judges of the High Courts present and past, fellow members of the bar, ladies and gentlemen, members of the press, and above all you law students who have come here in such good strength. Good morning and vanakkam. Those of you who have spared your Sunday morning to be with us will definitely not be let down because of what we are going to have unfold through the presence of these two distinguished speakers. I deem it a privilege, and a great privilege at that, to have been approached by the juniors of late Govind Swanathan to preside over the SGS award function for ethics in the legal profession that is being conferred on the renowned jurist Akhil Kureshi, former Chief Justice of Tripura and Rajasthan. When my friend Sriram, one of the senior most surviving juniors of Govind, called me for this purpose the other day, I must admit to being a little shell-shocked, and I may admit also extremely pleased. The reason for my exuberantly positive response is not far to see. From the day I stepped into Asia's largest court campus in Paris Corner 4 decades ago, I had been, and I continue to be, an unabashed admirer of Govind Somanathan. His several positive attributes have already been mentioned by Sriram and by some of the other speakers I'm sure will be doing likewise. For me, the four foremost qualities of Govind which I remember most were: 1, of course, his extraordinary legal competence; 2, his absolute integrity; 3, his protection and support to junior members of the bar; and above all this, his sheer style and elegance, coupled with the felicity of language anyone would die for. Even my father, late V.P. Raman, was in a way his contemporary, but chronologically they were almost 25 years apart. When my father passed away in 1991, even before hitting 50, I remember the call I got from Govind about the importance of keeping good health for a lawyer. I value and cherish his words. Alas, to my regret, I could never meet too much after that. The stables of this legend have produced very fine jewels who have adorned the bar and the bench. I intentionally use the word stables, for I understand both Govind and this morning's awardee, Justice Kureshi, share a common interest in equestrian sports. I refrain from naming all those juniors as it would cause a problem for me. The numbers are far too many, and I fear by inadvertence I may leave out some. Let me just say that Yato Raja Tato Janaha, when you have a king like Govind, how else would you expect his subjects to be? Like the blessings of Abu Banadam, let me just say, may your tribe increase. That the chief guest of this morning was to be my old friend and former colleague, Justice Rohinton Nariman, was just the icing on the cake. Like Govind, I was an equal admirer of his father, late Fali Nariman, the unquestioned emperor of the bar in his days. And the worthy son of the worthy father, Rohinton, accepted a direct elevation to the bench, and the rest, as they say, is history. It is indeed my pleasure and privilege to share a podium with a person of his eminence. I may jokingly add that it is also my fear, because everyone knows his eloquence and erudition. Thankfully, I precede him in speaking. The fact that Govind Somanathan's SGS Award for Ethics in the Legal Profession is not being given every year, but only selectively, I believe is not a sign of decreasing availability of worthy candidates, but rather an indication of the selection process and the exclusivity which the organizers want to attach to this conferment. That the recipient this year is Justice Kureshi adds luster to this award, for it is often said that the test of a good choice for being given an award or a citation is that the persons selected do not need any embellishment to their stature, but rather the value of the award or citation is enhanced by that preferment. In the choice of Justice Kureshi, the juniors of Govind Somanathan can never go wrong. I am sure the person introducing the awardee will be addressing you all of his lordship's sterling performance as an independent judge heading 2 high courts. References are also likely to be made to some of the bold judgments which I believe may have led to costing him his deserved place in Bhagwan Das Road. I will rest content with 2 other attributes of the awardee. First, as Sriram just mentioned earlier, is his enviable heritage as a scion of a family which have lived next to the residence of the Mahatma himself. The Gandhian principles thus run deep in your lordship's blood. The second is your lordship's very important judgments with respect to the protection of wetlands and lakes and wildlife sanctuaries in some celebrated cases like the Nal Sarovar Bird Sanctuary, Ranmal Lake, and the Gir National Park. I found them particularly engrossing because I have been acting as an amicus curiae since 2018 in assisting the Madras High Court in matters relating to protection of wetlands and sanctuaries. I congratulate your Lordship on this award and wish you all health and happiness in your future endeavors. Many outstanding judges of the High Court who failed to make it to the apex court are oftentimes more remembered in judicial circles than even the ones who providentially made the cut. Justice Kureshi is a standing example of the Indian judiciary's loss when he retired in March 2022. That within a year or so, yet another jewel of our judiciary, my dear childhood friend Dr. Muralidhar, also suffered the same fate, is, to say the least, lamentable. As the invitation for this function pointedly indicated that all the speakers will focus on the independence of the judiciary and what needs to be done to protect it, I begin the salvo that the choice of the right people at the right place itself is one of the pillars of independence, and we can collectively ponder here whether we are heading towards losing it in this area and also debate on how best to remedy the situation. Far greater minds than mine are going to address you all on that subject of judicial independence, and I will rest content with only repeating something that I have spoken about on a few occasions in the past. In fact, I mentioned it to about 1,000 students who are doing their enrollment function in the Tamil Nadu Bar Council a year or so back. This is regarding the importance of the role lawyers play in safeguarding the independence of the judiciary and the nation. The role that we collectively play in the well-being and advancement of society is as important as the role the judiciary plays in protecting it from any form of oppression. One of the classic misguided anti-lawyer jokes often doing the rounds is the reference to the sentence in William Shakespeare's play Henry VI, to begin with, let's kill all the lawyers. This is a classic case of misquoting and thereby misguiding the people. It was actually the greatest compliment made by the Bard of Avon, because the scene in which it is enacted is one where the character Dick the Butcher is addressing a fellow revolutionary anarchist called Jack Cade when they were all trying to conspire a coup against the monarchy, and knowing that anything so unconstitutional would be met with great resistance by the members of the legal fraternity, he made that character suggest that in order for anything unconstitutional to succeed, you would have to kill all the lawyers first. Why I said it was misquoting was because in the very next sentence, Shakespeare himself refers to the speaker as an array of rabble and a demagogue pandering to the ignorant. In today's age of social media, a word or a sentence can be twisted out of context, and this example is a case in point. Indeed, another aspect of the independence of our judiciary is the role that the social media will be playing in it in the near future. This, in a sense, sums up the enormity of the responsibility which we all collectively shoulder. I have but indicated one aspect of the independence of the judiciary. We are all anxiously awaiting Justice Nariman and Justice Kureshi to enthrall us with their wisdom. Without much ado, let me yield the floor to them. I once again thank the juniors of late Govind Swaminathan for having included me in this morning's lively event. Thank you all. Jai Hind.
Thank you so much, Advocate General. Now, I'd like to call on M. Vaidyanathan, Advocate, to read out the citation to confer the award on Justice Kureshi and the memento.
Good morning to all. I've been given the privilege of reading out the citation, which has been well crafted by Sriram, Panchu and his colleagues. S. Govind Swaminathan Award for Ethics in the Legal Profession, presented to Mr. Justice Akhil Kureshi in recognition of his exemplary ethical leadership and judicial integrity, and to honor his unwavering commitment to the Constitution and the principle of justice, we proudly present the S. Govind Swaminathan Ethics Award to Justice Akhil Kureshi, former Chief Justice of the Rajasthan and Tripura High Courts. Throughout his distinguished career on the bench and before, Justice Kureshi has epitomized the highest standards of integrity, fairness, and ethical conduct that were so dear to Govind Swaminathan. Justice Kureshi's unwavering dedication to upholding the principles of justice equally and the rule of law has served as an inspiration to all who seek truth and equity, not only in the legal profession, but also in our society at large. His profound respect for the rights and dignity of all individuals, regardless of their status or circumstances, reflects a deep-seated commitment to ethical jurisprudence. His judicial decisions have consistently been guided by a profound sense of duty to serve the public good and uphold the principles of justice without fear or favor. Moreover, Justice Kureshi's integrity and ethical leadership have set a shining example for his peers and future generations of jurists. His unwavering commitment to transparency, accountability, and ethical conduct has earned him the respect and admiration of colleagues, litigants, and legal scholars alike. In the face of complex legal challenges and moral dilemmas, Justice Kureshi has demonstrated exceptional courage and steadfastness in adhering to ethical principles at a tremendous cost of personal advancement and hardship to his family and friends. In honoring Justice Akhil Kureshi with the S. Govind Swaminathan Award for Ethics in the legal profession, we celebrate not only his outstanding contributions to the legal profession, but also his profound impact on advancing the cause of justice and upholding the highest ethical standards in society. Thank you.
I would now like to call upon law lecturer Vikas Muralidharan to please introduce Justice Kureshi.
Ladies and gentlemen, it is my esteemed privilege to introduce a titan of justice, a beacon of legal brilliance, and a true champion of the rule of law, and the recipient of the 2024 SGS Award for Ethics in the Legal Profession, Justice Akhil Kureshi. Justice Kureshi began his practice as an advocate in the Gujarat High Court in 1983, and his journey from an advocate to the hallowed halls of the judiciary was marked by excellence, integrity, and a profound commitment to upholding the rights and dignity of every individual. He was thus appointed the additional central government standing counsel from March 1992 to March 1998, and the additional counsel for the Income Tax Department in January 2000, where he represented the Income Tax Department in the Gujarat High Court up to December 2001. He was appointed an additional judge of the Gujarat High Court on 7th March 2004 and became a permanent judge on 12th August 2005. Upon donning the roles of a judge, Justice Kureshi's impact reverberated far and wide. His judgments, characterized by clarity, wisdom, and compassion, have left an indelible mark on the legal landscape. He stood for the rights of the marginalized and the vulnerable. He was appointed as acting Chief Justice of the Gujarat High Court on 2nd November 2018, before being transferred to the Bombay High Court on 14th November 2018. He took oath as the Chief Justice of the Tripura High Court on 16th November 2019 and was later transferred to the Rajasthan High Court, where he served as Chief Justice from October 2021 till his retirement in March 2022. In his farewell speech to the Rajasthan High Court, Justice Kureshi emphasized the importance that he places on the independence of the judiciary. Speaking about a change in the Collegium's recommendation that he be appointed as the Chief Justice of the Madhya Pradesh High Court to a recommendation that he be appointed to the Tripura High Court, he remarked that it was stated by a former Chief Justice that it was because the government had some negative perceptions about him based on his judicial opinions. In his trademark fashion, however, he stated, and I'm quoting him, "As a judge of the Constitutional Court, whose most primary duty is to protect the fundamental and human rights of citizens, I consider this a certificate of independence, and that failure, which is a product of He also stated that failure, which is a product of principled living, is more satisfying than success, which is founded on compromises. As we gather here to celebrate his illustrious career and enduring legacy, let us not only pay tribute to Justice Akhil Kureshi, but also reaffirm our collective commitment to the noble ideas of justice, equality, and the rule of law that he so passionately embodies. Please join me in extending a warm welcome to Justice Akhil Kureshi, a true paragon of justice and an inspiration to us all. Thank you very much.
It gives me great pleasure to now invite Justice Akhil Kureshi to make his acceptance speech and to speak on the topic of the importance of the independence of the judiciary and what needs to be done to protect it. Justice.
I hope the speaker from where the person is speaking does not signify his political ideology, or else I would like to shift to that side. Good morning, everybody, my esteemed guests, dignitaries on and off the dais, friends, ladies and gentlemen. I'm overwhelmed, and I do not know where to begin with. Let me start with an honest admission. Despite being deeply impressed by the culture, the heritage, the history, and the language and art of this region, I know very little about it. I was posted in 4 high courts, unfortunately none of them south of Vindhya. And my exposure to this place is principally through some books and as a tourist. I remember Malgudi days where the author says that in Madras, when a student comes home with exam results, the first question asked is, how many marks did you get in mathematics? And when the answer is 98 out of 100, a stern question is asked, where did those 2 marks go? Or through South Indian food, which when I was growing up in Ahmedabad was served in only one restaurant, run by a Marwadi family catering to Gujarati tastes, totally mutilating the authentic taste. So if you ever happen to visit Ahmedabad, please do not visit it. Friends, I accept this award with all the humility at my command. It is a special moment for me and my family. It is special because it is in the memory of an outstanding person, a great legal mind with sense of humor and basically outstanding human qualities. I've known him through Mr. Panchu's dialogues that I've had in the last couple of days, and I've known him through the book that he shared with me. The very fact that on a Sunday morning so many youngsters are present here is a proof of the fact that he touched many lives during his outstanding career. It is special because it came from, the initiation came from Mr. Panchu, one of the most respected senior counsel in the country today. Till recently, when I struck a conversation with him, I did not know him, though I knew of him. And my respect for him had gone several notches higher when he had written open letters in public criticizing certain preferential land allotments to be soon retired judges for setting up mediation centers. He has been a pivotal to all this program from the beginning to the end. He has piloted it. Thank you very much, sir, for including me in this and making me extremely comfortable in the last couple of days. I've had most extraordinary experiences in the last 36 hours or so. Thank you very much for that. It is special because it is given in the hands of Justice Nariman. Outstanding legal brain. He has left his deep imprint on the legal landscape of the country, be it IBC, be it arbitration, be it taxation. He has left his footprint. And more than that, through his words, deeds, and actions, he has shown what courage, what determination, what a single individual can do. Thank you very much, sir, for this. Though so many things are in public knowledge, neither Justice Nariman have spoken nor would I like to, except for saying one thing, that it is a matter of probably one of the greatest satisfaction for me in my entire judicial career of 18 years, that Justice Nariman and others like him trusted my integrity. It is also special because it is for ethics. When I became a judge on 7th of March 2004, I made a promise to myself that at the end of the day, when I demit the office, it would not matter to me if the people said that he was not a brilliant judge, as long as they say that he was as straight as they come. If today I feel, if all of you feel that I've redeemed the pledge that I made 20 years back, it is entirely because of my family. Sonal, my wife, my children, Aparna and Sahil, who had made no demands on me. Suffering the judicial and social seclusion for close to 20 years. And my dear friends, who made enormous sacrifices for me, upholding my integrity, my image, making personal sacrifices at all levels. I've been blessed to have several such friends. On any platform like this, the topic of independence of judiciary always comes up. I would like to share a few thoughts with you. I think we need to make some introspection at institutional and personal levels. When it comes to institutional level, I would like to flag two areas, the collegium system and the roster allotment systems. The most ardent supporter of the collegium system would not say it is perfect. And the most bitter critic does not present any viable alternative. We therefore have a situation where, like democracy, though not perfect, is the best system that we have in collegium. But we need improvements. Nobody can deny that. And what are the areas? First of all, we try to have transparency, where the collegium decided to go public about the reasons for acceptance or denial of a candidate. And I think then, and I think now, it was not correct. Because think of a position of a young lawyer who you have tried to persuade to give consent, is publicly told why his candidature is being rejected. He would say, I have not bargained for this, you invited me. Or think of a district judge who is in zone of consideration, who is being bypassed for reasons which are made public. He may have another 5 years in this field to spend. How do we expect him to do that? We also, therefore, this is one area I would park for the moment. The another area is that at the High Court level, the candidate is never taken into confidence as to what is happening to the process. We invite consent from, let's say, about 10 or 15 people. They are shortlisted. Not all 10 will get the recommendation even from the High Court level. Let's say 7 of them get. The 3 are never told that we are not accepting your candidature. They comes to know only when the 7 of them are invited to file formal declarations, and that through the corridors of the High Court. Even when the candidate has consented, his name is recommended, it goes further. For months on end, he has no authentic information as to what's happening. In Rajasthan, a candidate was recommended much before. When I went there, his rejection came finally after 2.5 years. I picked up the phone and called him and said, "It is my unpleasant duty to inform you that your candidature has been rejected." He said, "I'm thankful for information. One, I'm thankful that it has come to an end. I'm thankful that it is rejected. Now I can plan my life." This is normally not done. The candidate does not even know it's finally rejected. So my suggestion is that every stage, the Chief Justice of the High Court should take the candidates into confidence and tell him about the progress of the process, how far it has reached, where it has gone, what are the leftover stages, has it happened or has it not happened? Is it not unkind to a person who is invited to give consent, sometimes persuaded, he's not even informed that finally he's not being appointed? That's the second area. The third area is the gap between the High Court and the Supreme Court expectations must be bridged. The High Court recommends 10 names, the Supreme Court clears 5. Those candidates who have consented, their faith is diminishing every minute. The High Court and Supreme Court must sit down together and find a way why so many rejections are happening. And one of the thoughts which comes to my mind is that the role of the consulting judges should be reduced. That person has been in the High Court for years to gather his own likes and dislikes and prejudices. The collegium can always consult him informally. The requirement of consultation in writing, in my view, is not a healthy practice. Friends, these are some of the thoughts I have, and I don't claim that they're all correct. Everything has a flip side to it. As I said, the attempt to bring in transparency misfired. But my point, therefore, is that we need a system where we think through all these things and put in place a system which, to the best possible extent, can work more successfully. We missed that golden opportunity in NJAC judgment when the Supreme Court, after striking down the constitutional amendments in the law, left the task of finalizing the MOP to the court, to the Supreme Court on the administrative side and the government. In my humble view, that should have been done during the pendency of the petition. Maybe the Supreme Court was concerned about the impasse it had created for more than a year in further movements. But then the first part of the judgment could have been declared, matters could have been kept alive, the Supreme Court could have been in session, and then put in place a system which could have been far more efficient. My humble view is that 3 wise men and women, sometimes 5, are not enough to grapple and grasp all the aspects of the system that needs to be corrected. My suggestion, therefore, would be we should make a platform where we invite not the current judges, but the Chief Justices of the High Court select some of the past judges, social workers, people from civil society, and even the political people. Involve all of them. Make a group of about 20 people. Debate and deliberate all possibilities, positives and negatives and fallouts. Only when we can have a holistic idea of a system which will work best for the entire country. 3 or 5 people simply cannot foresee such complex issues which have far-reaching effect on the national level. On the personal level, on the roster system, a lot of debates are going on. the 4 Supreme Court judges who walked out and gave a public interviews had flagged the idea of one single person not deciding all such important decisions. Friends, in collegium system, the Supreme Court had said that any important decision of this nature cannot be left only to the President or even to the Chief Justice. He must be guided and advised by the collegium of other his colleagues. Why cannot the roster allotment be something similar? Maybe more broad-based, with a veto to the Chief Justice, but not a single person taking all important decisions. It is possible of some outstanding decisions. It is also possible of some mistakes being committed. At the personal level, the judges need 3 qualities to maintain total independence. 1, courage. Nothing in life comes without courage, not judicial independence for sure. 2, spotlessly clean image. If I have some soft underbelly, I'm going to succumb sooner or later to the pressures. And 3, total lack of personal ambition. The only ground on which a person can be corrupted is his personal ambition. Have no personal ambition, you have nothing to fear. And those who are used to playing around people's ambitions do not know how to deal with you. Friends, at the most elementary level, the judicial independence is not all about independence from executive or executive interference. It is far more nuanced. But in simple terms, my basic understanding is that anything, any action, any order, any judgment that a judge takes, which is different from his legal understanding, is going away from judicial independence. Nothing should matter to a judge other than his legal understanding, and if he expresses his legal understanding in his orders, that in my book is totally judicial independence. But at the end, we cannot have independent judiciary without independent bar. An active, vociferous, and fiercely independent bar alone can bring judicial independence. Friends, I would like to share a few more thoughts on other ideas. I was born about 13 years after India became independent. When I was growing up, those existential challenges were still facing the country. External aggression, abject poverty, hunger, unity of the country. The princely states and the princes took a while of persuasion and sometimes force to understand that in modern India, monarchy has no place. The time is up. India had fought 4 wars in quick succession, and war is a costly business. It leaves its impact on the country, on the society, on the economy. So when I was growing up, the nationalistic fervor with cautious optimism was in the air. On occasions like 15th August and 26th January, the speakers would tell us that it has taken many sacrifices of human lives. Millions of people have suffered for this independence to be achieved. Do not ever allow this independence to be frittered away. Do not ever surrender it. Sar kata sakte hain, magar sar jhuka sakte nahi. That was a slogan. Today, more than 7 decades after independence, we do not face those challenges. Due to relative stability, an idea of India has emerged and evolved. An idea of India where there is modern, liberal, scientific outlook. An idea of India where religious freedoms are non-negotiable, where tolerance is a virtue and not a weakness, where social, political, economic justice is a continuous onward march, where diversity is as important as unity, and where federal polity of the Constitution is respected as much as the power of the Union. If I were to speak to young students today on 15th August, I would say, do not allow this idea of India to be mutilated. And it is not as if this idea of India has evolved after independence or even with the advent of Constitution. The movement started much before. It had its roots in Jyotiba Phule's movement for social justice in Maharashtra, or Vinoba Bhave's Bhudan movement, or Dravid movement in Tamil Nadu, or peasants and workers' movements for better protection and better rights. And it has taken several centuries for the idea of India to crystallize. It is our duty to protect the idea of India as it stands today. Am I worried about the working of Constitution today? No. Because worried would be too strong a word. But I'm concerned. I'm concerned because our quest for growth ignores environmental impact. I'm concerned because as long as there is double-digit growth rate, we ignore human rights violations. I'm concerned every time there is a fake police encounter. I'm more concerned when such state-sponsored murders are lustily cheered by some sections of the society. I'm concerned when constitutional courts fail to protect the life and liberty of couples on the ground that they are living in immorality. When interfaith couples are not given protection because the marriage is otherwise required to be registered or approved or something, it's not done. I'm concerned when people in living relationship are not protected because the judge thinks what they are doing is corrupting the society. More so when a woman is already married and still living in a relationship. No question is asked whether the man is married or not. Though I'm concerned, I'm not worried because I have this tremendous faith and belief in this country and its people that it'll rebound. And my hope is not based on eternal optimism, an eternal optimist though I am, it is based on hard evidence. Because we have seen, when the Constitution of India was being framed, it was under the shadow of some of the grossest possible human rights violations and colossal loss of life and property post and pre-partition. And despite this, when the Constitution was framed, it did not carry any of its rancor and bitterness. It is premised on fraternity and world peace, where protecting the minorities' rights was at the core of many discussions in the Constituent Assembly. We have seen that for about 25 years after introduction of the Constitution, the Supreme Court failed to grasp the mood of the nation and failed to keep pace with the people's expectation of the change of society and social changes. Every time the social changes were brought up, the Supreme Court sided with status quo. We have seen how the movement from within and the exertion of pressure from the public demand, the Supreme Court slowly changed its stand. Justice Matthew, in N. Thomas' judgment, said Article 16(4), Clause 4 of Article 16 is not an exception to equality clause of Clause 1 of Article 16. It is just a more emphatic manner of saying what Sub-Article 1 already says. Because there cannot be equality amongst unequals. We have seen the judgments of Bandhua Mukti Morcha and Hussain Ara Khatun laying a foundation for the public interest litigation jurisdiction to thrive later on. All that we have witnessed, and the onward march goes on. I never give up hope that this country will rebound, and with all its vigor, the idea of India will be protected and it will advance its purpose in all times to come. I thank all of you to remain present here today, Mr. Datar, Justice Indira Banerjee, Mr. Ram, Mr. Advocate General, all of you who make your presence here make very special for me. Friends, at a certain stage in life, you look back. And the question that is uppermost in your mind is, did I live a good life? The answer should come from others, not you. Thank you so much.
Thank you, sir. I would now like to call upon Advocate Suchindran to please introduce Justice Rohinton Nariman.
Ladies and gentlemen, it is with profound respect and admiration that we extend our warmest welcome to our chief guest, Justice Rohinton Nariman. Selecting a chief guest for an award honoring ethics in the legal profession in the name of Govind Swaminathan is no easy task. The standards set are nothing short of exacting. However, in Justice Nariman, I believe we have found a choice that would resonate deeply with his spirit. For Justice Nariman stands as a testament to the Renaissance spirit within the legal profession, a multifaceted individual whose journey spans the realms of priesthood, law, comparative religion, history, and music, besides his roles as a senior advocate, Solicitor General, and a Supreme Court judge. Justice Nariman's educational journey from Bombay's Cathedral and John Cannon School to Harvard Law School embodies a lifelong commitment to excellence that permeates every facet of his remarkable career. Following a brief tenure practicing maritime law in New York, he returned to India, swiftly making his mark in the Bombay High Court and later the Supreme Court, where he joined the chambers of senior advocate K.K. Venugopal, who, and I can personally attest to this, on many occasions, till today regards Justice Nariman as the most brilliant talent to pass through his chambers in its nearly 70-year history. Designated as a senior advocate by the Supreme Court at a remarkably young age by Chief Justice Venkatchalaya, by amending the rules of the Supreme Court for designation, Justice Nariman's career as a lawyer spans over 3 decades, marked by over 500 reported judgments with many a novel and original arguments reflecting his expertise in constitutional, civil, and commercial law. As a jurist, and I use this term advisedly, in the highest court in the land, he has struck down Section 66A of the Information Technology Act and nullified instantaneous triple talaq on the ground of manifest arbitrariness, showcasing his nuanced and deep understanding of the preambular values of equality and the liberty of thought, belief, and worship. Justice Nariman's judgments have covered the entire ambit of subjects and include seminal contributions to taxation, arbitration, and commercial law, apart from constitutional law. Where in commercial law, his judgments have been pivotal in navigating the complexities within the Insolvency and Bankruptcy Code and the Companies Act of 2013. As a member of the Supreme Court Collegium, he has steadfastly stood up for judicial integrity and independence. In welcoming Justice Nariman, we honor not only his distinguished presence here today, but also the pursuit of excellence in the legal profession. Thank you.
It gives me great pleasure to call upon our chief guest, Justice Mr. Rohinton Nariman, former judge of the Supreme Court of India, to please speak on the topic of the importance of the independence of the judiciary and what needs to be done.
Justice Kureshi, Learned Advocate General, Sriram, Justice Indira Banerjee, High Court judges, ladies and gentlemen. How did the present system come into place? Why did it come into place? How is it being worked? Are all questions that we ask ourselves today. I want to take you through a brief history of how we have ultimately come to the second judge's case, what it really laid down, how it is being worked today, and whether any better system is possible. Mind you, I have really struggled with myself to try and think of some answer, and I have come up with one, which I'll share with you today. But to begin at the beginning, the founding fathers had an array of judicial systems and judicial appointment systems before them. And they really focused on two. One, the US system in which judges don't count at all, and the other, the English system, where you had a Lord Chancellor wearing 3 hats, so that when he wore the judicial hat, he sat in the House of Lords as its presiding officer. When he sat otherwise, he sat as a member of the executive, being a minister. And thirdly, equally, he would sit as a person who was in both capacities, as both judge as well as legislator. Now, in England, it is the Lord Chancellor who ultimately, after making consultations with various persons, gave a particular judge his name to the executive, and then the executive in due course appointed him. The American system, though it involved the president alone initiating appointment, and the upper house, the Senate, ultimately by a simple majority saying yes or no to the person, is not a system that commends itself for many reasons. However, it's interesting to note it has somehow thrown up the greatest judges. And this is remarkable. Sometimes it happens by happenstance. Now, the great John Marshall, who was their 3rd Chief Justice, was a man who would never have become Chief Justice but for certain remarkable things happening. One, he was Secretary of State to President Adams, who was the 2nd President of the United States. And they were looking for a Chief Justice when Justice Ellsworth resigned. And it was in Adams's last days. So Adams kept asking Marshall. Marshall suggested John Jay, who happened to be their 1st Chief Justice. 1st Chief Justice declined. Then they went to one of the senior-most judges who were sitting, Justice Patterson. And then President Adams said, no, but Patterson wouldn't do because Justice Cushing is senior to him. But then Cushing wouldn't do because he had already said no, and things of this nature. And then finally he just turned to him and said, why not you? And this is how Marshall actually got appointed. He was perhaps the greatest Chief Justice in any jurisdiction, because in his 34 years as Chief Justice, he actually made the United States of America. You must remember that the US is really a conglomerate of 13 states when it started, each giving up only portions of their sovereignty to a weak central government. It is Marshall who made that central government strong and who set the blueprint for the United States as it is today. Another great judge they threw up was Justice Holmes, who all of you have heard of. Now, Justice Holmes was appointed by President Theodore Roosevelt, and within a year disappointed the president who appointed him, so that he said that I could carve a spine easier from a banana than from this man who I've just appointed. And he turned out to be one of their greatest again, so he therefore was a maverick. And he again had a long tenure of 30 years. He was known for his great judgments on freedom of speech and for judicial restraint in the economic area. Then we had William Howard Taft, who again could operate within that system and become both president and chief justice. This is again something remarkable. First he became president, though he always wanted to become chief justice. And he appointed Edward White as chief justice, lamenting how much I want that post. I don't know why I am doing this. And then, of course, he left as president. And he was fortunate that President Harding, 7 years later, appointed him chief justice. And because he was president, he could lobby for a new Supreme Court building, which happens to be the building in which all of them sit today since 1935. Then, of course, you had the great Roosevelt appointees. You had Justices Douglas, Black, And these people, again, were outstanding, except that for the first 5 years of Roosevelt's presidency, he found that the old guard, so to speak, those who were 70 and above, resisted every New Deal legislation that he was trying to come out with. And 5-4 by a majority, they stuck down legislation. So that he thought of a unique court packing plan. And he said, for every justice over 70, we will appoint a new justice so that we make it now a court of 15, because there were 6 above 70 at that time. Fortunately, that didn't transpire because in 1937, one of the justices switched his vote and it became 5-4 upholding such legislation. Then we also had the great Warren era, where Earl Warren, who was a governor of California and not a judge at all, proved to be one of their greatest chief justices, with Justice Brennan in tow. And they were appointed again by a Republican President, Eisenhower, who again ruled the fact that he appointed a man like Warren as Chief Justice, because within a year of his Chief Justiceship came the seminal decision in Brown versus Board of Education, where racial segregation was sought to be done away with. On a sideline, they also appointed one of their weakest judges, a judge named Charlie Whitaker. And what I'm about to tell you is true. Whitaker walked out of a conference, because there's to hold conferences and the Chief Justice would decide who would write the majority opinion. So in this one particular case, United States versus Myers, he told Whitaker, Charlie, why don't you write the majority? And Whitaker walked out. Douglas was leading the minority. So Whitaker goes and tells Douglas, Bill, it'll be so difficult for me. I don't know what this case is really about. So Douglas said, oh, why are you bothered? I'll send you a draft. So you actually have a judgment of the US Supreme Court where the same justice has written the majority and the minority. You have Douglas's draft with Whitaker signing and Douglas as the minority. Anyway, you have all these funny things happening in that system. Judges are no part of that system. And somehow or the other, we chose the British system. Now, the British system, as I told you, consisted of a Lord Chancellor who wore 3 hats, so the judiciary was represented. Here, under our Article 124(2), when the President appoints judges, is the President alone appointing judges. There's no Lord Chancellor here. Which is why you have 2 other very important provisions. One is that that President can consult as many judges as he deems necessary for the purpose of appointment, and those judges can be Supreme Court or High Court, but with a proviso that in every case he has to consult the Chief Justice of India. How did this system work? Incidentally, our first Supreme Court was bodily lifted from the Federal Court, so that the 6 justices of the Federal Court became our first 6 Supreme Court judges. And of course, we had Justices Chandrasekhar Iyer and Justice Vivian Bose appointed to complete the number 8, which was the original number. And in the beginning, Justice Kanya was supposed to have lived for about 10 years and would have been chief for 10 years, but he died within a year. So the next senior-most chief judge was appointed Chief Justice. There was no convention then yet, but Justice Patanjali Sastry followed. After Patanjali Sastry, there was a problem, because the Prime Minister did not want Justice Mahajan, who was next in line. And he tried to sound out Chief Justice Chagla from Bombay to try and come. He tried to sound out Bijan Kumar Mukherjee, but fortunately none of this worked. And finally, because there were threats of resignation generally, Mahajan did become Chief Justice, and therefore one important convention was laid down that the senior-most judge, therefore, will invariably become Chief Justice. It had not happened in the Federal Court. Incidentally, Justice Vardacharya was the senior-most judge after Chief Justice Maurice Guire went. And Justice Vardacharya was superseded by bringing an English judge, Sir Patrick Spence. Chief Justice Guire wrote a letter to Lord Linlithgow, who was the Viceroy, lamenting the fact that they didn't even bother to consult him. And Lord Linlithgow very graciously wrote back and said, yes, you are perhaps right. We should have consulted you and should have stuck to the seniority principle. But anyway, fortunately, after the Mahajan episode, seniority as the senior most judge would then become Chief Justice was something that was set. Also in the first 18 years, the system worked well because two other conventions also developed. One was that the Chief Justice would give a name and not the other way around. So the Chief Justice would give a name for a vacancy in the Supreme Court and the executive appointed by and large, unless there was something radically wrong, in which case either the Chief Justice accepted it or if the Chief Justice insisted, then the executive deferred to the Chief Justice. In fact, in the case of Justice Raghubar Dayal, it actually deferred to Chief Justice Sinha because it voiced strong objection, but Chief Justice Sinha overruled them. And that went on for about 18 years. The problem really arose for the first time when Hidayatullah became Chief Justice in 1968. And he wanted two persons at the end of his tenure, Chief Justice Kotwal from Bombay and a judge called Justice Menon, both of whom were not appointed. So Chief Justice Hidayatullah left without two persons being appointed for the first time by the executive. Justice Shah, who followed, had a short tenure of 30 days. And in those 30 days, wanted Justice Bhagwati to come up at that time. And the executive said no. So already we find that there is erosion creeping in. And then finally, in Chief Justice Sikri's time, we actually had a reversal of roles because the government now started giving names. The law minister actually gave Chief Justice Sikri two names, that of Justice Chandrachud and Palekar. And the Prime Minister herself gave two names, that of Justice Dwivedi and Justice Beg. But when they gave the names of Justices Krishna Iyer and Nagendra Singh, who later became our World Court President, Justice Sikri put his foot down and they listened to Justice Sikri, at least insofar as the putting of his foot down was concerned. But the greatest threat really came after Kesavananda Bharati. All of you know that by a 7-6 majority, the basic structure doctrine was laid down and the absolute eve of Chief Justice Sikri going. And as soon as the judgment was pronounced and the Chief Justice demitted office, 3 judges were superseded. Now, this happened for the second time because the first supersession in 1965 was because Justice Imam was actually unfit. So that was a supersession which had to happen. And the next senior most judge, Justice Gajendra Gatkar, became. But this time, it was 3 senior judges who sided with a particular point of view who were superseded. And Chief Justice, the man who became Chief Justice was Justice Ray, who was constantly in the minority in a number of judgments and with the government. And as Mr. Daftari put it at that time, the schoolboy who wrote the best essay got the first prize. So that Chief Justice Ray then became. And this was the first blow struck at the independence of the judiciary, and it was a big blow. The second blow occurred shortly after, when Mrs. Gandhi lost her election case in Allahabad and an emergency was declared. Now, close on the heels of the emergency, you had a 39th Amendment Act, which in essence put the Prime Minister and the Speaker above the law. Because it said that you will now decide her election petition not in accordance with law, but in accordance with this amendment. This amendment lays down no law except to say that you will allow the appeal and nothing else. So that what followed was, for minority judges in Kesavananda, applying basic structure for the first time to strike down such an amendment. It's a remarkable thing that happened. And immediately when this judgment was delivered, which was between 7th and 9th November of that year, in 75, immediately after, Chief Justice Ray called a 13-judge bench within 2 days to review the basic structure doctrine. Now, this is where Govind Swaminathan stepped in. And we have to thank him because judges started asking inconvenient questions to the learned Attorney General at that point of time. Justice Khanna, for example, asked him, does the doctrine come in the way of any socio-economic legislation? The answer given was that no, in any case, there's nothing like essential and inessential. So obviously there was no real answer given. And the judges got testier and testier until suddenly Chief Justice Ray was put into a corner and they started asking, why was this bench constituted? So he said, well, the Advocate General of Tamil Nadu wanted it. So Granville Austin tells us, Govind Swaminathan jumped up and immediately said, I didn't want it at all. So at that point, again, they said no, but then the Advocate General of Gujarat wanted it. So the Advocate General of Gujarat also got up and said, no, I didn't want it. At which point then, it became impossible. And thanks to Mr. Palkhiwala's forensic eloquence, which reached heights which apparently have never been reached, within 2 days that bench was dissolved. And Kesavananda Bharti remained, so that one massive threat to judicial independence went there and then. But then there were other dark clouds looming on the horizon. One very dark cloud was the habeas corpus case. And the habeas corpus case again was decided by a majority of 4-1, Justice Khanna dissenting. And Justice Khanna's dissent was fortunately appreciated and made the law by me sitting with 8 other judges. And that was 43 years later when we said that Justice Khanna was right and the majority were wrong. That was one of the great things that I did in my judicial career. To have righted a wrong even though it was 43 years late. And of course, the other wrong could never be righted. He was superseded because of that judgment, with Mr. Palkhiwala writing a brilliant article in which I think the last line read as follows, that to the stature of such a man, the Chief Justiceship of India can add nothing. So this was the second very, very important blow to judicial independence. A third blow was 16 judges who were courageous, like Justice Kureshi, and who were transferred as a result. And that led to the judgment in Union versus Sankalchan Sheth, because Justice Sheth was one of those who had struck down orders under MISA, that is the Preventive Detention Act at that point of time. And again, by a majority, the court ultimately held that everything was within the hands of government. The transferee judge need not be consulted before he is transferred. And consult means consult. Of course, due weight will be given, but the ultimate decision is that of the government. So that was the first blow that was really struck against judicial independence. And then after Sankalchan Sheth judgment, our courageous Justice Khanna became chairman of the 80th Law Commission. And Justice Khanna then suggested something remarkable. He said that, look, for the first time, we should have a Chief Justice flanked by senior judges. This happened for the first time in 1979. And in his report, he said that you should be flanked by 3 senior judges when it came to Supreme Court appointments and 2 new senior judges when it came to High Court appointments. And of course, that was never followed, but that was something mooted way back in 1979. And then, of course, the stage got set for what is called the first judge's case, which is SP Gupta versus the Union of India, which was a 7-judge bench. And there again, important questions were asked about confirmation of persons who were additional judges and persons who got transferred. And the answers given were the same as that in Sankalchan Sheth, that you don't need to consult the judge in question, that ultimately it is the government alone who decides. And above all, when it comes to High Court judges, and there are other consultees as well, such as the Chief Justice of the High Court and the Governor of the state, the Chief Justice of India has no primacy. So that therefore, the government could select whichever view it wanted or not select whichever view, so long as there was effective consultation. Now, this was the unsatisfactory state of the law. And in 1987 then, you had the D.A. Desai Law Commission and the 121st Commission report. Because in that report, for the first time, it was mooted that there be a Judicial Appointments Commission, 11 members, of which 8 were to be judicial. And the judicial members were the Chief Justice, 3 senior judges, a retired Chief Justice for the first time. This idea of a retired judge comes here. 3 Chief Justices of High Courts making up 8. And then you have the Attorney General, the Law Minister, and 1 academic. This, of course, didn't, again, bear fruit. And then finally, you had a 2-judge bench look into the matter again in Subhash Sharma in 1990. And that bench doubted the correctness of the first judge's case, which is how a 9-judge bench got constituted. And this is how we now come to our present system. Because the 9-judge bench now held for the first time that independence of the judiciary is part of the basic structure of the Constitution. Therefore, every article that is viewed will be viewed in this light, the light of this principle. And when you view it in the light of this principle, Article 124(2) and 217 take on a completely different meaning. So that now, when it is mandatory for you, the government, to consult the Chief Justice, consultation is no longer just consultation, it is concurrence. So that for the first time, the view of the Chief Justice became binding on the government. Second, and equally important, for the first time, the Chief Justice was not trusted alone. He had to be flanked by 2 senior judges at that point of time. And the same for the High Court Chief Justice and the governor, who had to be consulted. And above all, primacy was to be given to the view of the Chief Justice of India, so flanked. So this actually turned the tables and turned the entire present system at that point of time on its head. So much so that judicial appointments now were in the hands entirely of the judges. Other important things were also laid down in that judgment, which unfortunately have not been followed. One is a timeline within which the other constitutional authorities have to respond. Now, 6 weeks was laid down by the majority judgment, in which the Chief Justice gives his view or his name to the government. Government has to respond, and 6 weeks are given. Suppose it's a High Court judge. Various authorities have to know what each authority has said, so a further period of 6 weeks is given. At the end of which, if there is a reiteration, which is unanimous, that is, all 3 say, the Chief Justice and the 2 senior judges, say that you have to appoint, then the government has to appoint within 4 weeks. Now, all this is laid down, but has never, unfortunately, actually been followed. So the system is not a bad one. The system, unfortunately, has never really been followed. And nobody has ever said that, look, 6 weeks have passed. How are you still sitting on the file? In fact, that's not the question. The point is, you should write a letter saying 6 weeks have passed, you have nothing to say. Within 4 weeks, please appoint, but that's never been done. So this is the first flaw in an otherwise good system. And this is why, we have seen this unseemly thing of the government sitting out judges who they don't like, so that a different collegium comes and then the name has to be given afresh. So the working of the system is what has led to a lot of problems. In 98, there was a special reference made and another 9-judge bench constituted. And that only tweaked this system by saying that merit is the first thing to be considered. Of course, you give some weight to seniority, you give some weight to region, but merit first. And you now broad-base the collegium into, instead of 3 in the Supreme Court, you have now 5. You have the Chief Justice and 4, and the High Court, it remains the Chief Justice and 2. But the whole unfortunate part is that, as I told you, this was not being worked as it should have been worked. And then, of course, you had various bills that were passed or sought to be passed from time to time. You had a bill in 1990 which had a particular system where only judges were involved. And at the High Court level, the governor also came in. You had, in 2003, a bill which lapsed, which sought to make the Venkatachalaya model the model of a judicial appointments commission, which was essentially that you have a Chief Justice of the Supreme Court, 2 senior judges, and then you have the law minister and 1 eminent person who is selected from a panel. That also lapsed. 2013, then you had one other bill where you had an equal representation in a judicial appointments commission to be laid down by an act of parliament. That also lapsed. Until finally we now come to the 99th amendment. And that amendment, we are told, was passed unanimously with just 1 member of the Rajya Sabha dissenting, Mr. Ram Jethmalani. Otherwise, it was passed unanimously. And that amendment said that you will have the Chief Justice, 2 senior judges, and you'll then have the law minister and 2 eminent persons to be selected from a panel which consisted of the Prime Minister, Chief Justice, Leader of the Opposition. That, as you know, then got struck down by a 4-1 judgment in 2016. And today, this is where we stand. Now, the misfortune of this system is, 1, it has not operated according to its timelines. 2, it has not somehow thrown up the best. We still have persons like Justice Kureshi and many others who have somehow not reached us. Because, essentially, they have been found to be as meritorious as you can be. If you are too meritorious, apparently, you are out of the zone of consideration. And that merit consists of being fearless and really independent. So the moment you are really fearless and really independent, out you go. This is the unfortunate part of a system which is meant to protect us. So, what other system could be better? I agree with Justice Kureshi that this is like democracy, a system with huge flaws. We can perhaps better it, make it more transparent, etc. Certainly better than the executive appointing. But is there some other system which can be put in its place? Now, having thought a lot, I came to the conclusion, and I took this from a letter that Justice Khanna wrote in 1980 to the law minister, that why don't you have a panel of the Chief Justice and 3 retired judges? According to me, if you have a panel of a Chief Justice and say 4 retired judges and nobody else, it will subserve judicial independence, but then the problem is how do you appoint the 4 retired judges? Because that's another major problem. And if you appoint them for long enough, then transient Chief Justices won't be a problem. So if you give them a term of 5 years again, no problem. I have thought of a method in which they could perhaps be appointed. You could first have names given by practicing members of High Court bars and the Supreme Court bar. Now, practicing member would be a person who would, you can define it, would have at least 100 filings, 150 filings, 200 filings in that particular court, together with arguing cases of the same number. Now, if you have these people who were to select, say, 1 or 2 judges who they are told they must select because they must only look at constitutional values being protected and nothing else, you would then get about 22 names or 44 names from the High Courts. Likewise, you could get a panel of 20 names from the Supreme Court. And from these names, which would then number about either 40, 60 or whatever, you could then have the entire Supreme Court judges sitting, deciding as to who the best person would be, and then have a panel of 4. So that if the entire Supreme Court, today we have 34 judges, you keep the Chief Justice apart because he is going to be part of the panel. So you have among 33, each one voting for the person he thinks is best. And if you notch up the maximum number of marks from these, then the person who notches up the maximum number of marks, followed by the second, followed by the third, followed by the fourth, could perhaps be the pool of retired judges who then become a permanent commission for a period of 5 years. And once these persons have the power to appoint, then of course they will consult everybody, because the important thing also is to get as many inputs as possible. So the widest consultation possible, after which finally by a majority, if these persons say, Mr. X is to be appointed, he has to be appointed within, say, a period of 2 weeks or whatever. I cannot think, I've been racking my brain, I cannot think of any better system. Of course, today in England, you have the Judicial Appointments Commission, consisting of 15 persons. But there you have a lot of lay persons. So you have an equal number of lay persons with judges, 2 members from the bar, and 1 person from a judicial tribunal who is not a judicial member. But I don't think lay persons is a good idea, because lay persons are liable to be influenced. I don't think they know. Retired judges are in the know, in the loop. They know exactly who to appoint, who not to appoint. And particularly if they are outstanding persons, then you probably will get an excellent crop of persons, and you will get what Justice Verma envisaged in the second judge's case, which is persons of outstanding merit, meaning thereby persons imbued with constitutional values. Of course, all this is utopian, but at some point of time, maybe this will happen, and if it happens, at that point of time, utopia will come to the earth. Thank you all very much.
Thank you so much, Justice Nariman, for those words and thoughts. I'd like to call upon Senior Advocate N.L. Raja, who will be presenting the 2 justices with his book that he has co-edited on the Madras High Court. Thank you, Senior Advocate N.L. Raja. And now I'd like to call upon Advocate Aparna Mukherjee to deliver the vote of thanks.
Good afternoon. Thank you all for being here today. Thank you, members of the dais and participants. For us, from Mr. Govind Swaminathan's family, it's a very proud moment for us to be here and participate in today's function. We've heard really, really good speeches from all the members of the dais, and I'm really embarrassed to be carrying a piece of paper here after hearing Justice Nariman talk for 25 minutes without even a sheet of paper. And Justice Kureshi, thank you. So, on a personal note, there are so many things that we learned and values that we learned from my grandfather. My mother and I, we lived with my grandparents from the time I was 2, so my formative years were spent in my grandfather's house. My grandfather taught us that, for him, his family was all of us and very much his juniors. He had an office at home, and every day his juniors would come over and spend the morning there before going to court, and again in the evening they would come back. So we learned that family was a very inclusive concept, and we are happy to be here with our family today. Another thing was that we constantly had visitors from all walks of life coming in and out of the house. I think for me as a child, that was the greatest education, because it taught us how to interact and be with people from any background, from any place in life, but to maintain your integrity, to be able to speak out and to interact naturally with everyone who you encounter in life. During school years, this got me into a lot of trouble, but then later on in life, it helped me well. He was very strict on punctuality, which you may have heard. And in fact, every morning we used to leave the house at 5 a.m. to go horse riding. And if we would come 5 minutes late, he would greet us with good evening instead of good morning. So he was really, didn't have tolerance for punctuality, for not having punctuality. So we'd like to congratulate Justice Kureshi and thank you for accepting the award today. What you said about independence of judiciary and for judges to have courage, a lack of personal ambition, and a spotless record really were very powerful words. Thank you for that. We'd like to thank Mr. P.S. Raman for being here. Mr. P.S. Raman's family and ours go back many years. And my grandfather and his father were, though separated by age, like he said, were in the High Court working hard at the same time. Mr. P.S. Raman spoke about the important role that advocates play in the independence of the judiciary. Thank you. We'd also like to thank Justice Nariman. For me to try to summarize his speech was virtually impossible. But I think one important thing that I heard him say was that to move towards judicial independence, that we could look at a panel of 4 with the Chief Justice and 3 retired judges who would then do extensive consultations and then decide using a majority who would then be appointed as a judge, and their word would then be followed. So thank you all, and many thanks to the organizers, Mr. Swaminathan Juniors, and all their colleagues and friends who made up the team to make today possible, and all the participants who have come here to be with us on Sunday morning. Thank you.
Thank you so much. We will all now rise for the national anthem.
Jana Mana Adhinayak Jaya He Bharat Bhagya Vidhata Punjab Sindh Gujarat Maratha Dravida Utkala Vanga Vindhya Himachala Yamuna Ganga Uchchala Jaladhi Taranga तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे